So thank you. I'm going to go through this presentation and have a couple of moments during it where we can ask questions, but a lot of times when people have questions, it comes up later. So we'll go back and forth regarding that. If you want to show your face, it's really great because I don't have the benefit of being in a room and seeing everyone. So if you show your face, I get a little bit of feedback, a smile. You know, there's a thumbs up option that you can give in Zoom. So those are awesome if you're willing and interested in doing that. And that helps me. We have 2 breaks built in to this. So that you know, if you have a need to stretch, you can always do that or go to the bathroom, but we also have that built in so that we all don't lose our minds. So thank you again, and I'm going to get started. First
Mario,
of all,
sorry,
yeah.
Can I just interrupt? Anybody that's on the phone or otherwise didn't get the materials, they are posted on our website in the events section. So the PowerPoint, if you're on the phone and you want to follow along, it's on the website. Thank you.
All right, so actually, let me see. Jessica, why don't you throw up the poll? We'll close it right now, and I'm going to see where people are coming from and what brought you to this meeting. Awesome. So I see that the majority of people work for a nonprofit that provides help to tenants or other clients who may or may not be just tenants. That's awesome. And we have elected officials, employees. We have folks from legal service providers, community organizers. That's awesome. And nobody's planning on Zoom bombing, which is great. So I'm going to jump in. The second question is kind of the starting point of this whole presentation, which is how is it that anyone is able to afford an apartment in New York City? I haven't updated this for a couple of years, but the last time I checked, it was $48,000 more or less for the average tenant household. And in terms of the rents, you know how bad that is. I don't have to get into that. This is I believe the 8th time I've been doing this presentation for Housing Court Answers. And the first year I did it, I was working on a kind of quick analysis of the difference between what the median income is for tenants and the asking price for a new apartment in those neighborhoods. And the worst neighborhoods in terms of affordability, as an example, in Washington Heights, you'd have to pay 78% of what your income is. This is all pre-tax income, by the way. In Brownsville, the same. In Mott Haven in the Bronx, you'd have to give 100% of your paycheck to your landlord. And if you're in Harlem, you actually have to give them more money than you earn. On its face, that doesn't sound possible. So we need to figure out what's actually going on here. And this pie chart of New York City renters, this is only renter households, starts to get to the heart of the question, which is, of the renter households, what kind of households are these in terms of the housing they live in? Surprisingly, the yellow chunk right here, those are the market rate apartments. Those are people who are paying the asking rent at whatever the landlord wants it to be. The red chunk is public housing. Then we start to go into the smaller categories, rent control, which predates the rent stabilization system and is dwindling. We'll get into that later. Mitchell-Lama, which was a program that lasted about 20 years and built new housing for the purpose of affordable housing. Some people, I included this even though it's not a type of housing, just to say that people with Section 8, that's a way that they can pay the rent regardless of what type of housing it is. There's a smaller category called project-based Section 8, and that means that the owner of the building has a contract whereby every person living in there has a Section 8-like apartment, but they can't take it as a voucher and move to another unit. It's only based on that apartment they live in. And then that tiny little sliver right here, that's LIHTC, that's low-income housing tax credits, that plus the 80-20, which and inclusionary housing, which is so small, I don't think you can actually see it. Those are the buildings where you see a sign on the side of the building that says affordable housing for New Yorkers. Those are the quote unquote affordable housing units that the city subsidizes private developers generally in order to provide housing at lower than market prices. And that's a tiny sliver. Everybody else lives in a rent stabilized apartment. So the blue chunk over here is rent stabilization. It's more than twice as many apartments are rent stabilized as if you put every single other affordable housing program together. And that's why it's such a vital program, and yet it gets very little attention. So I'm going to go through the questions as to people answering. How is anyone able to afford the rent in New York City? Everyone is rich or homeless? I hope not, but I feel that way a lot. Most New Yorkers don't actually pay these super high rents. That's the one I'm focusing on. And what I mean by that is that the majority of New Yorkers are not paying what the landlord wants them to be paying. They're paying what the law permits them, the landlord, to charge in the rent stabilized apartment. And that is the majority of New Yorkers. More people live in an apartment that's not a market rate apartment by far than who are paying the market rent. Unfortunately, that is the market rent is growing category. And anyone who answered the rent is just too damn high, you're absolutely right. And the people who have peanut butter sandwiches or ramen every meal, I'm sorry, we will send you something a little more healthy. But I've been through that too. Now, the question number 3, what is the best borough? Interesting. So Brooklyn is trying to represent as the top borough. We will see at a poll that's actually a quiz midway through. So we will determine whether Brooklyn is in fact the best borough very soon. So rent stabilization covers not quite, but very close to 1 million apartments. And there's about 2.5 million New Yorkers who live in a rent stabilized apartment. If you had to build enough affordable housing to replace the rent stabilized housing stock, we would have to add a 6th borough, which looks very much like Brooklyn if you look at the map. And I'm calling that Affordableville. Because it is literally the size of Brooklyn. That's how many, if you took every single person who lived in Brooklyn, that's how many people live in rent stabilized apartments in New York City. So the point of this presentation is to learn how we can identify if an apartment is rent stabilized, the basic protections offered by the rent stabilization system, and in particular, how that's different from market rate tenants, the legal ways that the rent can be raised if you live in a rent stabilized apartment, and a little bit about how we can protect these tenants and keep them in their homes, which is a lot about knowledge and understanding. So rent stabilization is a state law in New York that provides rent and eviction protections to people in certain types of housing in New York City. And there's 3 other counties, Westchester, Rockland, and Nassau, that are part of the system right now. And thanks to changes that occurred last year in the law, for the first time in decades, other parts of New York may join this system and start joining the category. But what's really key about rent stabilization is that if you really want to break it down, there's only 2 things that you need to know. One is that a rent stabilized tenant has the right to renew their lease, and it's not up to the landlord. The landlord is supposed to offer everybody the option to renew their lease in a rent stabilized apartment for the most part. We'll go into the minor exceptions. But if the landlord doesn't give you a renewal lease, your old lease stays in effect indefinitely. So the failure of the landlord to renew the lease doesn't actually accomplish anything. And that's unfortunately not true if you're not in a rent stabilized apartment. The second is that the rent increases are limited. They're not what the landlord wants to raise the rent. It's set by the Rent Guidelines Board for the most part, which is the Rent Guidelines Board is a city agency that determines how much a lease can go up when it's renewed. It's usually a few percent. We've actually had in the last few years, for the first time ever, a 0% increase. And right now they're hovering in the 1 to 2% category. And that means that no matter what the landlord wants to charge or could get if it were a market rate apartment, that's the most that they're allowed to increase on a lease. And those two rights go hand in hand. You can't have a limit on rent increases, but then allow the landlord to just not renew the lease. And renewing the lease, having the right to renew, is kind of pointless if there's no limit on what the landlord can charge. So those two pieces are pretty essential and linked. And that's really the fundamentals of what the system is about. So by having those two protections, rent and eviction protections, tenants have the ability to set roots in a neighborhood that are very similar to what a homeowner can do. They can remain even when the neighborhood gentrifies, and they can enforce their right to repairs and services without fearing that the landlord will retaliate against them for doing so. And for an example, I work with a coworker who's in an apartment in Brooklyn that is not rent stabilized. And last winter, she wasn't getting enough heat, but was afraid to call 311 because she knew that if she caused a stink about the heat, the landlord might decide to just not renew her lease and she'd have to look for a new apartment. If you're in a rent stabilized apartment, you have the right to renew. You know your rent isn't going to go up. You don't have to worry about that. I threw this in for the first time this year because there's lots of discussion about rent cancellation and rent strikes, including for political reasons being done to support that. And in a rent stabilized apartment, again, you run much less risk. There's some risk always whenever you do a rent strike. But if you're trying to appeal for conditions that need to be repaired, for example, you're not going to be retaliated against because you have these fundamental rights. So a quick history on rent regulation. The system that we know today grew out of World War II era price controls. There were earlier rent regulation systems in New York, but the one that we currently are covered by originates from this era. And it came from an era when there were profiteering, anti-profiteering laws and price controls on a whole bunch of items, including rent. So for example, today, there's a lot of discussion about people profiteering off of hand sanitizer and toilet paper because of the coronavirus emergency. And that was what was going on during the World War II era, except it wasn't limited to just hand sanitizer and toilet paper type items. It was across the board what matters in your life, including the apartment that you live in. And when the war ended, particularly and soldiers were coming back home, they were coming home to a very tight housing market, particularly in urban areas where a lot of people had been moving from rural to urban areas to fill factory jobs during the war. And activists and the unions joined together to try to make the rental housing market rent control system a permanent fixture and not tied to the war, but tied to the tight housing market, which was the reality in New York and only getting worse at that point. At its peak, rent control as a system covered 2 million apartments in New York, which is more than twice what it is now. And it literally covered every building at a certain moment that had been built by that time that was at least 2 apartments. The only units that were exempted at a certain period of rent control were 2-unit houses, were single family homes. So it was such an expansive system. It's really hard to imagine today. But it was really part of an era that I think a lot of us are fighting to return to in certain ways in terms of what your expectations were of government. Progressives that right now are fighting for rent regulation to cover all apartments, free tuition at CUNY, a public health infrastructure that's close to universal. That's kind of what New York City was at that era, and it's a fascinating time period to study. But what happened in 1971 is landlords had successfully managed to lobby enough, primarily Republicans that were mostly not representing New York City districts, to get the New York State legislature to end rent control through a system called vacancy decontrol. What that meant is that when a rent-controlled tenant moved out, the apartment became a market rate apartment. So you didn't lose rent control when you were living in the apartment, but for the entire city, every rent-controlled apartment would become a market rate apartment when people left. And as can be predicted, that created a massive incentive for landlords to displace rent-controlled tenants. The rents went through the roof. And the tenant movement organized for 3 straight years. From what I've read, literally 1 million tenants went to Albany in protests over the course of a 3-year period, putting a lot of pressure on the state legislature. And they came up with a compromise. And the compromise is rent stabilization, which at the time was considered to be slightly weaker than rent control. And it largely was similar as a system in terms of how it was run. What they did is the difference primarily between rent control and rent stabilization was what buildings were covered. And what they decided to do at that point is to exempt buildings that had fewer than 6 apartments in the building. So it was kind of a small building exemption. So in this picture here, if you're in that lovely little townhouse squished between the 2 large apartment buildings on either side, that little townhouse would not be covered by rent stabilization. And the apartment buildings on either side of it, which clearly have more than 6 apartments, more than 5 apartments in them, would be covered. And that's kind of the law that we're living with today. So there's really a few key pieces that make an apartment rent stabilized. One is that it's a rental building with 6 or more apartments. 2 is that it was built and occupied before 1974. And 3, that it's a privately owned building. There is no opt-out if you fit that category. So rent stabilization is not a system that landlords choose to be in. If you fit those 3 criteria, you're a rent stabilized landlord, right? Your building is rent stabilized. It's not the kind of thing that you have to participate in as an affordable housing program. So if you want to screenshot one thing in this one slide, this would be my recommendation. If you remember nothing else from this training, I would remember this. 6 or more apartments within the same building. The building was built and occupied in 1974, and it was privately owned. The 1974 piece is because that's when the law took effect. So basically, it was every single building that had 6 apartments and was private as of the date that the law took effect. And they've just never updated that. So it's in 1975, it was 1 year old. Now we're decades old. But that's the reason why it was 1974. It was every building at the time that the law took effect. So the exemption for small buildings causes a major disparity in terms of who's covered. I wish I could see the chat feature. I haven't figured, I don't know why I'm missing this, but what's that?
One question. I was
yeah,
waiting for
please.
a pause. So the question says, I work for HCA Hotline. Should we advise rent stabilized tenants in Westchester, Rockland, and Nassau counties the same way we advise rent stabilized tenants in New York City? Do the same laws and rights apply?
Oh, that's a really great question. The laws are pretty much identical. The major difference is that they have a different, the New York City Rent Guidelines Board determines rents for New York City, and each of these counties has their own rent boards. That's one of the main differences that they have. But in terms of the protections, what covers you, the 6 units, the 1874, that part is exactly the same.
And that's statewide, right, Mario?
Yeah, those particular rules. I don't know if there's been any opt-ins. I'm a little bit out of the loop with regards to that, but I know there's some other parts of New York that are interested in engaging and joining this system now that the option became available last year. So since I can't see the chat, Jessica, do you recognize the neighborhood? This is actually not too far from you. It is you. This is Washington Heights. Washington Heights is primarily buildings that are 6 or more apartments. And that's just the nature of how the neighborhood was built. And as a result, it's about 95% of Washington Heights tenants are rent stabilized. This neighborhood in South Brooklyn, just looking at it, you know, unfortunately, the majority of people are not. They're older buildings, but most of them don't have at least 5 units in the building. This is a form of really crummy discrimination that I think has very unequal effects, and it makes no sense to me that we want to continue with this at all. The size of your building should have nothing to do with your rights, but unfortunately, that's the world we're living in. So I oftentimes would end up, when I'm talking with a tenant, especially in the housing court situation where I didn't have paperwork that the tenant could show me, they don't know whether their building is old or not. And they don't know, you know, they might be able to have a sense of that. So literally some of these silly questions like, do you have a fire escape? Does your building have, you know, beautiful details? That one you might want to skip. But do you have a loud clanky steam radiator in your building? All of these things were phased out by the 1930s and 40s. So any of those would indicate that your building is old. But if you really want to check, the better way is to go online. And I'm going to pass this on to Jessica for just a second, because there's a really terrific website that can tell you the age of your building, the number of units in your building, and other really important things for advocates to know. To share for a second?
Yeah, so I thought I allowed it to both share at the same time, but can everyone see? I just pulled up who owns what. So step back. On that screen previously, you type in the address and it covers all 5 boroughs. And then when you pull up the screen, it's going to tell you, it consolidates information from various city websites. So like HPD, Department of Finance, ACRIS, all the city records. And then you can get a profile of the building. You can see the block and lot number, the year that it was built, the number of units. They have a calculation for how many rent stabilized units. You can find the name of the owner. You can find the name of the managing agents. And then on the side, bear with me here. On the side of the screen here, you have a link to HPD, Department of Building, Department of Finance. Also, on the top, you can see timeline of complaints and violations from HPD. And you can see the portfolio of that particular owner, which is all the buildings that that owner owns. So it's a great organizing tool. And plug for next week, next Friday, we're going to have a training with JustFix, where they're going to talk about this and other tools that they have for researching the landlord. So please, same time, same place, next Friday. So that's all I want to really say about it. Mario.
Perfect. Thank you. And you know what? During your
while I had your
demonstration, I figured out how to see chat. I feel so awesome.
So then you see there's a new chat.
Yes, so now I can see everyone's. Oh no, and now it disappeared. What the heck? It disappears when I'm presenting. Oh my gosh.
So the question, I'll just read it to you. Even if a building identifies as rent stabilized, some of the units may have been deregulated a few years ago, or there are illegal overcharges. How would we identify those rent stabilized apartments?
Yeah, I think we're going to go into deregulation in as the presentation goes. So I'm going to just continue with the presentation because that comes up as we go.
Can I also just add one thing, Mario, before we move on? Sometimes those brownstones that you showed in the picture before usually have less than 6 apartments, but in some situations, there's more than 6 independent families living there. And in that situation, sometimes attorneys can win rent stabilized rights for the tenants living there. So be aware that the rent stabilization is like, we're trying to expand it in the advocacy community, and one of the ways is that. So
yes, and also too, what matters is an even easier thing is that in 1974, if there were 6 units in the building, if at the time when the law took effect there were 6 apartments, by default, everyone was rent stabilized. So even if the number of units in the building has reduced because they've combined units since then, every tenant who's in an apartment that existed in 1974 when there were 6 units. Those are all rent stabilized tenants. So there was a period in New York where it was much, much more common for apartments to be cut up into small, either kitchenettes, studio units, or even single room occupancy type arrangements. But anything that had 6 units at the time the law took effect absolutely would be covered. And as Jessica said, some lawyers are capable of making arguments that have been holding up that even tenants that have lived in buildings that have since the law took effect. But that's something you really should talk with a lawyer about. It's not an easy case to make in front of the court. So I wanted to make, to jump back into the presentation, the subsidy that a tenant pays is really not indicative of what type of apartment they're in. So if somebody has FEPS or if they have Section 8, I've asked a lot of tenants what type of building or what type of apartment do you live in? And their answer might be a 2-bedroom or a 1-bedroom, or, you know, I'm in a Section 8 apartment. But Section 8 for most people is a voucher that pays the rent, but it doesn't indicate what kind of an apartment it is, meaning, is it a market rate apartment? You're paying the full rent that the landlord wants, or that it's a rent stabilized apartment and that what they're paying, their portion wouldn't change, but what the rent is. And what the reason why this actually matters, tenants sometimes don't think it matters because they're not paying the actual landlord's bill in full. One of them is that programs have rent limits. These programs will not pay infinitely no matter how much the rent is. The programs don't have the right, they can't force the landlord to renew the lease for that tenant. If it's a market rate apartment, they're not able to change that scenario. And that if the person were to lose their subsidy for any reason, rent stabilization would still be in effect for that apartment. So if the tenant were to lose the voucher that helps them pay the rent, they'd be way better off in a rent stabilized apartment where the rent is not going to be limitless in terms of its increases. So it really does matter regardless of whether a person has a voucher or not. There's a smaller category of rent stabilized buildings that go beyond that simple rule of 1974 and 6 or more units. And these are buildings that were newer and the landlord chose to join one of the tax abatement programs. So the big one is 421A. 421A is just a type of a property tax exemption that really is tremendous benefit to the landlord. And in exchange for that, they have to enroll their apartments within the rent stabilization program for the length of time that they are receiving the tax break. And it's kind of pointless in certain respects because in my mind, because the landlord can set the initial rent at whatever they want. I've literally seen $15,000 a month rent stabilized apartments that were in new luxury buildings, which means that the landlord was getting what they wanted from day one. They got to set the initial rent, plus they're getting tax breaks. And all it did really was say that for the duration of these tax breaks, the increases are going to be rent stabilization. I don't really think that's quite on the same level as an apartment that's affordable from the beginning, but that is something that is a category of rent stabilized apartments. And I suppose after the 20th year, it's possible that the rest of the housing market has gone so much up that the rent stabilized tenant in a J51 or 421A apartment is actually going to be paying a lot less than the market. J51 is a rehab program that you don't even, it's for repairing major building systems. And that also applies to newer buildings. I'm not going to spend too much time on that, but so apartments are no longer rent stabilized for a few reasons. One of them is if the building was purchased by a school, hospital, or cultural institution, basically a nonprofit, before the tenant moved in. If the building converted to a co-op or condo before the tenant moved in. These types of changes in building structure mean that future tenants are not rent stabilized, but existing tenants get to keep their status. So basically, if you were a rent stabilized tenant and then Columbia University bought your building, you would not be affected whatsoever by that change. But if the institution was using it for theoretically their own use, and they decide to rent apartments as part of that, the people moving in are not going to be covered. And this usually comes up in the context of a co-op building. So you might have a co-op where there's a lot of rent stabilized tenants that were there before the building converted to co-op. But if they have units in the building that become rentals at that point, from the point that it's a co-op forward, it will never be, those people will never be rent stabilized tenants. So you have to be kind of careful. Then there's this last category, and this is the major reason why we have lost a lot of rent stabilized apartments in the last few decades. There was a period I'm calling the dark days of rent regulation in New York City, 1993 to 2019. Landlord lobbyists had managed to use two very effective negotiation strategies with the New York State Legislature. This is the first strategy, and this was the second strategy. And they were pretty effective in creating a pretty awful scenario in New York City where there was thunder and clouds every single day of the week because we were losing tons of rent stabilized apartments. So in the 1990s, landlords were successful in lobbying for vacancy decontrol for rent stabilized apartments, just like they were with rent control. So basically, every time a rent stabilized tenant moved out, apartments were allowed to be converted to market rate prices. We're going to go into the details a little bit later because it wasn't an automatic every single apartment is deregulated, but it was loose enough that any landlord that wanted to deregulate an apartment could deregulate every apartment if that was what their goal was. This occurred through legal and illegal methods. Sometimes landlords deregulated without following the rules and got away with it. They had the promise of doubling, tripling, even sometimes 6 times what the rent would have been from the rent stabilized tenant to the market rent. You can literally go from $1,000 a month to $6,000 a month, depending on the neighborhood you're talking about. And this caused landlords to try to push out tenants in various ways, like refusing to make repairs, harassing them, false lawsuits, bribing them, which is called a buyout, where you give a chunk of money, like $5,000, $10,000, $15,000 to just give up your apartment and leave. The harassment, as an example of how bad it was, there was a landlord called Pinnacle that owned thousands of rent stabilized apartments that one month decided to sue every single tenant. I believe it was about 35,000 apartments on the same month, making the same allegation that the people in the apartments were not really living there, and forced every single case to go to the housing court system and be dealt with one by one, even though it was a complete BS fishing experiment. And the goal was not really to win every single case. It was to intimidate enough tenants who were afraid of even going to court or who just didn't show up because they didn't take the day off of work, to the point that a handful of them would just give up their apartments and leave. We lost a number that unfortunately was never able to be calculated. And that's a real problem, but we lost really close to 500,000 apartments over the course of those 2.5 decades. It was equivalent to losing the entire city of Philadelphia, San Diego, or Dallas. New York City lost as many rent stabilized apartments that became market rate luxury apartments as any of these 3 cities have in terms of their entire housing stock. The good thing, we're in 2020. After 3 decades of fighting, tenant groups finally were able to turn it around. And in 2019, the rent stabilization laws were finally renewed without any vacancy decontrol, and the law was made permanent. It used to be a system where the law would be renewed for only a few years and then it expired. And when we last renewed it, this was really thanks to decades of fighting on the behalf of rent stabilized tenants from organizations you probably work for today that were part of a fight to make this system work again. And thankfully, we are not going to lose any more rent stabilized apartments under this law using those methods. Unfortunately, so the vacancy decontrol law is gone. Apartments now that are rent stabilized stay rent stabilized when a person moves out. The opt-out provision that a landlord had that we'll go into a little later is no longer in effect. But this new law did not return apartments to the rent stabilization system. So if the building we're looking at here is a rent stabilized building, there may be a number of units within this building that have been deregulated during that period. And now only some of the apartments, the ones that are, that I didn't hide, those are the rent stabilized tenants, while the other units in the building have already been deregulated. It makes for a very confusing situation for both tenants and advocates. And so we'll help get to the bottom of how you can determine that. Just as comparison, if you're a market rate tenant, you're on your own. There's no rent limit, so $1,500 could be $5,000 the next month if you're a market rate tenant. And there's no protection for market rate tenants who, even if they can afford the rent and the landlord doesn't want to renew their lease, market rate tenants don't have a defense if the landlord says, I just want you to leave. The landlord can say, I want you to leave and I don't really want to tell you why, and that's fine. So it's a massive difference versus in a rent stabilized apartment. The safeguards are super strong. Rent and eviction protections remain. Again, even if there's a change in building ownership, even if the neighborhood gentrifies and the market rate prices are going way up, and even if the landlord hates you, which the landlord probably does hate you because you're not paying the market rent. So we're going to take a couple-minute break right here. Please stretch, go grab a cup of coffee or water, and we will return in a couple minutes.
Do you want me to launch the poll now or after?
Yeah, actually, thank you. Let's launch the poll right now. Oh man, everyone here loves brownstones, and apparently nobody likes walk-up tenement buildings. What's up with that? Yeah, I think the answer to the question for your hardcore New Yorkers, unless you didn't get along with your grandma, so many people want to take over their rent-stabilized apartment from a family member who's been in there for a long time. And that's a system called succession. So for the 18% of you who have grandmothers in New York City or wish you did, I'm with you on that one. Nothing like being able to afford your apartment. All right, I'm going to come back to the training, and now we're going to get into the nitty gritty of how the rent increases work, starting with who's in charge of running the system. There's a agency, it's a state agency called New York State Homes and Community Renewal. They're in charge of enforcing the rent regulation system. This is a self-enforcing system, which basically means, as I say, HCR is the referee, but somebody else has to yell foul. They don't have investigators going around knocking on doors. They do have a small division that does investigatory work. But for the most part, they're not going around with traffic cops trying to enforce, the rules of rent stabilization. You have to bring it to their attention, and then they will look into the issue. We'll get back to that a little bit more. Rents can be increased for existing tenants in a couple of ways. The most common one that we see is when the lease is being renewed. So by law, a rent stabilized tenant has they have an option of one or two. They can do a 1-year renewal lease or a 2-year renewal lease. And it's the tenant's decision. It's not the landlord's decision how long you want to renew your lease for. The amount of increase for 1- and 2-year lease renewals is up to the Rent Guidelines Board, which is a nine-member body that is elected or appointed by the mayor. So because it's a mayoral choice, there is significant difference between what the rent increase is when you have a conservative pro-landlord mayor or one that might be a little bit more progressive. So They've gone as high as 8%, and we've had as low as 0%. It is a slightly political process. The increases set by the Rent Guidelines Board most recently were 1.5% for a 1-year renewal and 2.5% for a 2-year renewal. And that's tremendously different than a person living in a gentrifying neighborhood that might have to pay literally a 20% increase if the landlord thinks they can get away with it. The other ways of increasing the rent are through the landlord investing in the building. And one of them is called a major capital improvement. So the picture here of the scaffolding is indicative of something that you could be facing an MCI for if your landlord is doing, which is that they're either replacing a major building system or doing some sort of an upgrade that applies to across the whole building. It doesn't just benefit one apartment, it benefits all the apartments. So now, a new roof, even though it's only over certain people's apartments, benefits everyone. If you replace windows, you have to replace all the windows in the building, not just one apartment's windows. And then the amount that the rent increases is a formula. So in this example below, if $500,000 was spent by the landlord, first they divide by the number of rooms in the building. And so a room could be the kitchen, living room, or a bedroom. And then once they've calculated the total number of rooms, so say there were 200 rooms in this building, then they divide by 144, and that's going to end up at $17.36 per room. And say you live in a 3.5 room apartment, that would be $60.76. And a half room is a concept that depends on how they count different rooms. So obviously a bedroom and a living room are a full one, but many kitchens are considered half rooms. And the tenants who are facing an MCI have the ability to challenge that the landlord actually is entitled to that increase. The kind of challenges they can do are that the work doesn't qualify. Like if you do something that's cosmetic and is not related to the building's functioning, like if you put in a chandelier or if you decide that you want to put marble floors in the lobby, that's not going to count. Another one is that it's not a building-wide change, that it's only for certain apartments. Like for example, the windows. I only put the windows in the front of the building, but I didn't do the back of the building. That wouldn't count. A huge one is that the landlord didn't spend the money. Maybe there was a nonprofit that gave them a grant. They can't claim an increase for money they didn't spend. And then the other one is that the work actually didn't work. So you put in a new roof and it immediately leaks. Now, the period at which you can collect an MCI, I see a question from Damali that how many years can you collect it? It used to be 7 years. Actually, Jessica, I didn't write it down on my notes. What is the current year amortization period? Because this just changed in the 2019 laws.
I have to look it up. Sorry, I don't know.
Thank you. That's a great question. I used to have it in the back of my head. That's why I didn't have the notes, is because it used to be a 7-year period, and now I believe it's 50. Yeah, one person saying 15 years, Deborah. That sounds about right. Now, if the increase represents more than a 2% increase of what your rent for a specific apartment is, the landlord can't collect it all at once. They have to phase in the increase. So depending on whether it would represent more or less than that, that depends on how much they're allowed to charge as the increase every year. So if it's in excess of that, they have to phase it in 2% increments each year until they reach the full amount. Then there's the second method of increasing. I guess, Jessica, if you want to verify that on the chat, that would be awesome. Thank you so much. The other way of increasing the rent through the landlord making improvements is that if the improvement is to an individual unit, it's called an individual apartment improvement, IAI. So as an example, if you live in an apartment and you have this really crummy refrigerator that looks really rusty and nasty, you can tell the landlord, look, I want a new refrigerator. And If you ask for one that's used, or say, I'm willing to accept a used one, they actually have to give you one that's clean and in good working order and are not allowed to charge for a rent increase for it. But if you say, you know what, I'm tired of living with this stupid, nasty refrigerator. I actually like one of those really cool ones that makes ice cubes. Can you get me one of those fancy stainless steel ones? And you insist on a new one, the landlord is entitled to raise your rent by 1/168 of the cost of the improvement for 30 years. So you will end up paying for that refrigerator through the rent increase in that manner. And it's only 1/180th if there's 36 or more units in your building. So the formula depends, again, on the number of units. But again, if you don't want to pay that and you're a current tenant, you can simply say, I'd like an appliance in good working order. Now, what determines...
Mario?
Yep.
Can I just add that 1/168th and 1/180th is part of what changed in HSTPA's and new rent laws last year, and it's huge. It used to be like 1/60th and 1/40th.
Yes.
So that is a huge improvement that we have and a way to limit the increases.
Thank you. I was definitely a point to make. The amount that the landlord can increase, so much less than it was just a year ago. And this is particularly important for apartments that are vacant, because a tenant can say, look, I really don't want the fancy refrigerator. I want the decent working refrigerator. Please don't charge me at all. But when the apartment is vacant, there's nobody to push back against the landlord in terms of what they're spending, or even know what the landlord is spending. So in order to figure out what the apartment's rent can increase when there's no tenant, you first have to understand this concept of legal rent. The word legal is very deceptive. How do you know if the rent is legal? Well, you can't guess. You have to do your research. It's not based on market rents in the area. It's not even based on similar apartments in the same building. Those can differ very much. And it's not even the amount that's written on the lease necessarily. The amount written on the lease might not be the legal rent. The landlord could be overcharging you. And the law supersedes the lease. So how do you figure it out? Well, starting, you have to get a rent history. A rent history is basically a listing of registrations that the landlord has sent to DHCR, the agency in charge of rent regulation. It's considered confidential, so I unfortunately cannot request this for an apartment I'm interested in renting. They won't give me a copy of it if I don't live in it. But if you do live in the apartment, you either call HCR, they'll mail it to you, or you can visit their office. Now they actually have a method for making a request online. So you can follow this link and actually get your rent regulation history in any of those three methods. Now, here's the thing. The legality of what the landlord is saying there isn't necessarily being vetted. So landlords are allowed to register the legal regulated rent, and HCR doesn't verify anything. So the stamp here, they just approve the rent increase without any review. This is not a real stamp, but that's basically what they do. It's a registration system only. It's not something that anyone looks at. And landlords self-reporting are able to get away with a lot of fraudulent registration, particularly when a new tenant moves in, because in most cases, the new tenant has no idea what the previous tenant was paying, and they don't really have a way of figuring it out unless they know the rules. So how can I figure out if the legal rent is legal? Well, the first method of doing it is that there's a magic crystal ball that'll tell you the rent, and I will accept Venmo, Cash App, Zelle, or Bitcoin, even though I don't really know what to do with Bitcoin. So Jessica, can you put those on the side of the screen, please, for anyone that wants to know the legal rent of an apartment? Okay, actually the way that we can do it is doing math. So anybody that doesn't like doing math, you can send me the Venmo, but I'll tell you just in case you do. So to figure out if rent increases are legal, what you do is you look at what the previous tenants were paying, and you calculate what they were paying plus what a legal increase would be. And Nowadays, thankfully, tenants that are moving into a new apartment in the last 2 years are entitled to a lease rider that shows them how the landlord allegedly moved the rent from what the former tenant was paying to what you're paying. That's not something people used to get as part of their new lease. It's also not something anyone's verifying. So you have to check that. But for tenants that moved in prior to 2018, landlords had the ability to do generous rent increases, two major reasons of which they're no longer allowed to do. One was called a vacancy bonus. The tenant groups called it an eviction bonus, because automatically by getting a new tenant, you got a 20% increase in most cases, slightly less if it was a 1 year. But for a 2-year new lease, you'd get a 20% vacancy bonus. Huge incentive to kick out a tenant. And then there's something called a longevity bonus that kicked in depending on how many years the tenant had lived in the apartment. And so something that had less turnover, you would get even larger rent increase. And those totally unwarranted increases, thankfully, finally ended in 2019 with the new laws. If you are looking at an older rent history, there's lots of resources, advocates, and sometimes lawyers, depending on how the situation is, can help you go through it to determine if there was a rent overcharge. But basically, the increases in rent from one tenant to the next have to pretty much be explained through individual apartment increases. That's the mechanism for increasing the rent from one tenant to the next. So a new tenant, you don't really know what the old rent was. You don't really know what renovations occurred when you first move in, and that makes fraud kind of easy. So unfortunately, the landlord doesn't have to file anything with HCR. They can just charge the higher rent. However, under the new law, and again, this is only for the past year, has this been the case, they're now required to keep records of the receipts and explain them on the new leases. They've always been required to keep receipts, but they've never been required to actually make an explanation until recently. So you as a tenant have to look at your apartment, look at the rent, and see if that was actually something they were capable or entitled to increase it using these IAI increases. So certain improvements, we covered the appliances and fixtures, those would qualify for IAIs, but a lot of things don't. So for example, painting and floor sanding, that's really common between apartments. That's not considered a new or improved thing to do. Painting and floor sanding and redoing the floors that are existing, that's not covered. If the landlord had already charged the previous tenant for that as an individual apartment increase, like buying the old tenant a new refrigerator right before they moved out, that wouldn't be covered. And everything that fits into the category of repairs, those would not be qualifying. If you're doing something like putting new floors in, you have to do it throughout the entire apartment for it to count. Same thing with walls. You can't just replace the walls in one room. You'd have to replace the walls in the entire apartment. And that makes for very few things that are actually qualifying in a lot of cases. Now, another huge improvement, IAIs are only allowed 3 per 15 years. There's a $15,000 cap per apartment, and $15,000 means how much the landlord has spent and is eligible to use as a basis of a rent increase. So you take the $15,000 and you divide it by the formula, the 1,186, and you end up with, in a building that has fewer than 35 units, they're only allowed to raise it less than $80. And if the building has more than 35 units, even less, it's about $83. This is phenomenal. This is huge. Go back 1 year, there was no limit at all on rent increases for IAIs. The landlord could say, and the formula was different too. As Jessica said, it was 1/40th for buildings that were fewer than 35, 1/60th for buildings that were 36 and more. That meant that in a smaller building, say it had 24 units, a landlord could say, you know, I just spent $80,000 on renovating this apartment, so I'm increasing it by $2,000 a month. And they would be allowed to do so. And that would help them deregulate the apartment completely, so that rent stabilization would disappear. We now have a cap of basically $90 on the rent increase from one person to the next. That means if your grandmother paying $271 for her apartment moves out, the next tenant's entitled to an apartment that's less than $400. This is huge. And then, of course, there's also the maximums for the 15 years. So this is a game changer. It's definitely a new and improved formula. I fully endorse this, and I really hope it is a game changer in New York City, as it should be. Now, the thing is, you do have to be careful, because it's the current tenant who gets to make the claim to HCR and make sure that the law is being followed. And if I were a landlord looking to make money, what I would bank on is that 99% of tenants are never going to know the facts that I'm telling you, never bother to look into it, and just pay what they see the advertised going rate is for the neighborhood. There is a limit to the length of time for challenging a rent increase, and it's, I believe right now, 6 years. It used to be 4 years. So if you are able to prove that your landlord began charging you a rent that is illegally high, you are entitled as a tenant to a full refund of the amounts that you overpaid your landlord, plus triple damages for that. I know a person who came to get help for her housing situation. She happened to be in an apartment where she could only afford it by having 4 roommates. So it was like a 4-bedroom apartment. Everybody was crowded, and it was something close to $2,000 a month. And after a few years of living in there, she finally looked into the rent history. They found it fraudulent, and she got a $150,000 check in the mail back from her landlord when she was moving out, because the landlord had been overcharging her the whole time. It is a bunch of money potentially on the line. It's worth doing. The way that you can challenge the legal rent is 2 ways. One of them is there's a form that you can fill out, and it's called a rent overcharge complaint form from HCR. This is the RA 89 is the code for that particular form. It's free. The process can take about 1 year sometimes, and you have to pay the current, what the landlord is telling you is the rent during that period. You don't get to say, I caught you on fraud, and then immediately start paying the lower rent. You have to wait for a decision from HCR on whether or not it was legal or illegal. The other way is that you can raise it as a defense in a housing court case. This is the kind of thing you'd want to do with a lawyer. For a variety of reasons. It can be complicated, but there are advantages to doing it in housing court if you are represented by a lawyer. One of them is that you can actually force the landlord to testify in a trial as to how they can justify these rent increases. So for example, if somebody, the contractor, you could put the contractor on the stand at the trial in housing court and say, so you're telling me that you charge $80,000 to make this apartment look still crummy? Like, what exactly did you do? Make the contractor vouch for it. But it is, again, something for a lawyer. And basically, either way, whether you're doing it in housing court as a defense or whether you're doing it to HCR, you're really looking at the receipts and verifying that the receipts make sense. You're looking at the date of the receipts. If you moved in 2016 and they provide the receipts for work and the date of the receipt was 2017, well, that wasn't work when the apartment was vacant. You were there. They couldn't qualify for that. You look at turn your refrigerator, pull it out from the wall and look behind it and find out the model of your refrigerator. Because what if they actually are charging you for a refrigerator that you never got? And things like the landlord hiring their own people where they can pass money to each other, that's outlawed. So you have the ability to challenge an IAI increase. And to be honest, this is really going to be important for people who moved into apartments prior to 2019 in particular. Because at that point, the basis of a rent increase was a limitless amount of individual apartment increases. I would look at the apartment. Ask the tenant if you're working with them to take pictures of it. Does this apartment look like it was renovated? Not really. On the other hand, it's a gorgeous apartment and I would completely take it immediately if it were being offered to me. In part because it's beautiful, and in part because I can tell that they didn't do any work that they're qualifying for an individual apartment increase.
Nice.
Now let's take something that you might see that, yeah, okay, fine. They did probably renovate it. This doesn't look like an original kitchen.
Yeah.
But when you look at it, those look like probably the original floors. Yeah, they probably got a $400 or $500 refrigerator and maybe a $300 stove and a $300 cabinets from IKEA. I don't think they really spent that much money on it. You're doing a detective investigative work. So that's basically how a landlord is allowed to increase from one tenant to the next. I think we're probably going to open this up for some questions about this. Actually, this is probably a good time for questions. Do we want to?
Before the break, I just want to say one thing real quick. The IAIs, the overcharges, it used to be a little bit hard. They wouldn't look back more than 4 years to see, unless you could prove fraud, they wouldn't look back more than 4 years when they were considering an overcharge. And under HSTPA that passed last year, they drastically increased like the things that look like fraud to be able to prove fraud. And they made it much, much easier to look back farther in the rent history. So I got a private question about tenants who are already in place and filing overcharges. It's a good idea now to look back. It's easier now to make and win overcharge complaints than it was a year ago at this time.
Nice.
There was also a chat about MCIs that I wanted to go back to.
Mm-hmm.
I don't know if you want to unmute yourself, Bob, and talk about your experience with MCIs.
Okay, we're not hearing Robert right now, but can we go to Damali had a question regarding the MCIs and whether they're in addition to rent guidelines board increases. Damali, do you want to unmute yourself for a second?
Yeah, so
Shit. Where's Robert?
I worked for Housing Core Answers, and I had a tenant that was asking about MCIs and IAIs and how that works. And one of her questions was if that was in addition to the RGB increases. And so I thought that was a good question. I wanted to ask that.
Absolutely. Yeah, thank you. So the answer is that yes, it's in addition to the rent guidelines board increases. So if this year the landlord was allowed to raise the rent 1.5% based on the rent guidelines board increases, and the landlord did an MCI and the MCI increases the rent by another 2%, it would be both the 1.5% for the rent guidelines board and the 2% for the MCI. Now, of course, the MCI is not a percentage increase, it's a dollar increase. The 2% is because that's the most they're allowed to in a particular year. So the MCI would be a specific dollar amount that's added. The increase would be a percentage on the base rent, but they're allowed to collect both at once, yes. That was a great question. So did we get Robert Tilley's question? Is he able to talk?
Yeah. Yeah, I sent that in because we were able to use a Google photo that I guess a DHCR followed up on and denied the MCI portion there for landscaping that never happened.
That's great. So just summarize what you put in the chat in terms of how did you do this? Were you living in the building? Do you work with these tenants?
No, I was working with the tenant and you know, he claimed that the MCI wasn't done, but apparently the landlord did do the masonry work. And that showed up in that photograph. I didn't go to the building, but I tried to figure out a way of researching it to see if the tenant's claims could be substantiated.
That's
and,
great.
That happened. So
yeah, so your situation is one where it sounds like they were entitled to some of the money, but not all of it.
Exactly.
So in this case, you can challenge an MCI and say, you know, I'm challenging the work that you did in, you know, you say you put in a new boiler and that in the time period that you did the boiler, you also, you know, were doing other work that affected tenants. Maybe they did put the new boiler in, but the other work associated with the installation of the boiler, like new pipes or something like that, never actually occurred. That's often common. You know, a landlord will throw in a bunch of things and say, yeah, we did this while we were doing that. And I'm including them all as part of the same thing. And you can challenge it and win part of it, even if you don't win all of it. Oh, that's really interesting. So Catherine is talking about the fact that there was a Court of Appeals decision changing the amount of time for an overcharge complaint to be looked back. It was 4 years for a long time. The legislature, as part of the rent renewal laws, changed the look back period. And you might be right. I wouldn't be surprised if that was the basis of a challenge. You probably sound like you might know more than I do because I'm not really in the advocacy world anymore. And I think let's take a look at that. There's a really great place for people who are on the higher level of rent regulation research, which is the Housing NYC listserv. It's an email listserv of people who are in the advocacy or legal representation world asking questions of each other and sharing information. This is actually something that you could probably get a PhD thing in if they offered it. Rent regulation can get complicated when you start getting into the specifics, to the point that even lawyers doing this for 30 years need to ask each other questions about how certain things work. All right, so preparing for the break, before everybody goes, I want to introduce you to a game. We're gonna do a little bit longer of a break this time. I'm gonna make it a 5-minute. This is definitely your time to go grab the sandwich if you were going to. When you come back, or if you're not gonna go do more than a stretch, please answer the poll for rent stabilized or not. This is our quiz/game. You, at this point, are responsible for the borough that you said is the best borough. It could be the one you live in, it could be the one that you work in, or I guess the one that you wished you lived in. But when you're answering questions, you are answering them on behalf of the borough that you say is the best in New York City. Here's how the game goes. The poll, I'm throwing out scenarios at you, either buildings or apartments. And your answer is, you're saying, is this apartment rent stabilized or not? There are 3 ways to answer the question: yes, no, or I need more info. You have to get your answer explained in order to get the point. So guessing is not going to get you anything. And just to make it a little bit fancier, this year I'm going to do something new, which is that you have to decide which borough you don't like. So the least favorite borough, which means that if you get the answer wrong, they get your point. If you get the answer right, they lose a point. You can end up in the negatives. I'm going to try this for the first time. So we're going to throw the new poll for rent stabilized or not up. We will have more time for questions, but we're going to take a break right now. I'm going to throw the timer on. It's a 5-minute break, and when we come back, we will jump into the answers to the questions for rent stabilized or not. I forgot. I'm going to throw on a 5-minute little audio clip if it works. Oh, no. So that if you want to keep the volume on, you know when 5 minutes is out. Special song for coronavirus.
Well, you can tell by the way I use my walk. I'm a woman's man, no time to talk. Music's loud and a woman's walk. I've been kicked around since I was born. It's alright, it's okay. When I look the other way, you can try to understand the New York Times of Come on. Whether you a mother, whether you a brother, we're staying alive, staying alive. In the city, bringing in everybody, shaking, we're staying alive, staying alive. Staying alive, staying alive. Staying Well, you can tell by the way I use my walk. I'm a woman's man, no time to talk. Music's loud and a woman's walk. I've been kicked around since I was born. It's alright, it's okay. When I look the other way, you can try to understand. New York Times of Whether you a brother or whether you a brother, we're staying alive, staying alive. In the city, bringing in everybody, shaking, we're staying alive, staying alive. Staying alive, staying alive. Staying
Are we back? Is that 5 minutes? Yay. All right. So I think we should give automatic points to Mary Martinez, and who else said it was awesome? Kim
Yay.
Ellison, we should give them automatic points because yes, Corey Henry and the Funk Apostles, amazing. If you haven't checked them out, maybe go do their Tiny Desk concert is a great introduction. So I'm happy to have a chance to share them with you. So if people who want to participate in the game, what I'm going to ask folks to do is, first of all, I want to see you if, unless you're, you know, look, we're all in our pajamas, let's get real. So, and we're all having great hair days, all of us. So show it off if you feel comfortable. Turn on your video. Yay, it's so nice to see more people, awesome. And then when you are ready to answer, I want you to say, just type into the chat box area the borough that you are representing. And so I have right here the official tally sheet for what the boroughs are. And I think we'll open up question number 1 to whoever types in the chat box first with their borough's name.
Don't all shout at once.
Uh-oh, okay, there we go. Is it Johaida?
No, I think it was Kim.
Oh wait, you're right, there's one above that, Kim. Wait a minute, Kim already got an automatic point, so
It's
Kim.
both Brooklyn.
Yeah, so Kim, you were the first for Brooklyn. Can we turn on Kim's audio and video if she's comfortable?
Everybody has the power to turn their own audio on and off.
Okay, I'm on.
All right. So first of all, before you get into your question, what borough should lose a point if you get this right, or get the point if you get it wrong? What's the borough that you're just hating on today?
Oh, geez.
Come on, we're all New Yorkers here. We know how to get into that.
Sorry, Jessica, it's Manhattan.
Oh, all right, okay. So the question is, a 20-unit walk-up apartment building built in 1902. It's an apartment building built in 1802. Is it rent stabilized?
Yes.
All right. So that would be a point for Brooklyn, right? And Manhattan loses a point just for being Manhattan, apparently. I think we should give Manhattan a chance. So the next one is a 50-unit luxury pre-war elevator apartment. Wow, this is a Central Park West apartment building. It's gorgeous. It was built in 1903, but it's a luxury. Okay, let me see. Who from Manhattan wants to take this question? It's an apartment building. It's a rental building in 1903. Who is from Manhattan? Manhattan. By the way, I'm definitely trying to be tricky, but I'm not trying to be too tricky. You got to listen to the words. And if I say, like, for example, rental is rental. You know, it's an apartment building means that it's a rental. So can I get an apartment, somebody to answer this question from Manhattan? If not, throw out your borough name. Nobody from Manhattan wants to get their point back. We're going to do it by video or audio. All right, I'm going to go to the next person from the list of earlier. Johaida, do you want to answer this question?
Number 2?
Yep.
But yes.
Okay, but what about the fact that it's a luxury pre-war elevator building? This is a luxury building on Central Park West. Doesn't that make it market rate?
No, it was built in 1903 when the rent stabilized law still exists.
All right. Thank you. I think we get another point for Brooklyn. So Brooklyn gets a second point. Yeah, the point with this is that I think a lot of people, I threw that question, and these are the easy ones, but it's partially because people have a sense that, like, oh, if the neighborhood is really fancy or if it's a really great apartment, it can't be. Now, in all likelihood, there's not going to be very many in some of the wealthy neighborhoods. You're not going to find that many in the Village or on Central Park West or in Soho, because for so many decades, these have been highly sought after neighborhoods that when apartments were deregulated, it's likely that it could be deregulated. It's likely the landlords pushed very hard to deregulate them. But there are plenty of tenants still in there that have lived in their apartments for decades before deregulation was even allowed, and those people are still rent stabilized. And thanks to the 2019 laws, the next tenants will be too. So next on the docket, rent stabilized or not, 3-family house in the Bronx built in 1820. I'm going to go to a different one, different borough. Sonia, you want to represent Queens? It's a 3-family house in the Bronx built in 1820. Sonia.
I'm here. Rent stabilized.
It is? Okay, why?
It seems like it seems as if it was built for quite a while and it has been for a rental property. Maybe the persons have moved out of the area.
Okay.
And they have had it for a rental property.
And Sonia, what borough do you just hate? You're not feeling it.
Pardon?
What borough do you hate?
Bronx.
The Bronx. Oh, shoot. Unfortunately, Sonia, you just gave the Bronx a point because it actually, 3-family, 3 units. It doesn't matter that it was built in 1920. It's a 3-unit building. So it doesn't meet the the more than 5 rule. It's fewer than 6 apartments, so it's not rent stabilized.
Okay.
I'm sorry, but the Bronx, you just gained a point.
Can I just add, Mario, that
Yeah.
my answer to that question would be needs more information.
Yeah.
Because if it's a 3-family house that has been broken into 6 individual units, with a lawyer, you could win rent stabilization rights for those tenants.
Well, the reason I said 3-family was to indicate 3 units, and that's the terminology. So I'm going to push back a little bit, but you know what? Just because of that, I will take the point back from Queens, but I'm going to still let Bronx keep their point. I'm not trying to be too tricky with this. It's about the language that I use, but let's do this one, for example, because this is an interesting one. 3-story brownstone in Harlem built in 1909. I want to get more people who want to start joining this. The next person I saw was Rudy, but we need a few more people to represent their boroughs. Rudy. You there, Rudy?
Hear me. I don't have video, but I believe you can hear me, correct?
Yeah, it's a lot of echo, but I can hear you.
Okay, very good. Yeah, so 3-story.
Well, first, who's the borough that gets your point if you get it wrong, and who loses a point if you get it right?
I believe it was Brooklyn.
Okay, so Brooklyn. Wait, you can't lose or gain the same point. You're representing Brooklyn is the one you want to win. Who are you hating on today?
The Bronx.
Okay, the Bronx is gonna be on the line because of this. So, is the 3-story brownstone in Harlem rent stabilized or not?
Rent stabilized.
And tell me why.
Most likely there are more than 6 apartments in the building. I can't tell. I believe I may have answered that with not enough information. I'm not sure.
Okay, so which is it? Is it not enough information or is it yes?
Not enough information.
Okay, is that your final answer?
Yes.
All right, cool. So Rudy, I was almost gonna take the point away from you because it sounded like you said yes, but the truth is that the answer is I don't know. Because we don't know how many units are in this building. In this particular case, I actually was looking for a building that on the building search thing that had 6 apartments, even though it was only a 3-story building. They'd probably be small apartments, but this is actually a 6-unit brownstone. So this is a rent stabilized apartment, but you wouldn't have known this based on what I said. 3-story brownstone? The answer is I don't know. 3 stories only tells you how many stories. It doesn't tell you how many apartments. So Brooklyn is doing pretty good. They got 3. Next one is a 7-story public housing building in Queens built in 1954. And I'm going to go to Wendy because Wendy's defending Manhattan. I'm going to guess, Wendy De Leon, do you live in Manhattan?
Yes, I do.
Okay, so let's get Manhattan their point back.
Thank you. 7-story public
Wait,
housing.
wait. Who does Manhattan not like? Do you want to take the
I'm
point away
hating on
from?
Brooklyn.
Yeah, because they're the ones that
Yes.
were trying to hate on Manhattan to start with. Good. So what's the answer to the 7-story public housing building built in Queens?
No, it's not rent stabilized because it's public housing.
Even though it meets the year criteria, 7 stories doesn't say anything, but let's assume there's at least 7 apartments. But you're absolutely right. Manhattan gets a point. So now the 0, they lost one, but they now have one. And I'm going to take a point away from Brooklyn. Have I been doing this tallying correctly? I've been doing the tallying totally wrong. Oh my gosh. This is the first time I did it this time. But we're going to take one away from Brooklyn and we're going to add one to Manhattan because you're absolutely right. Public housing is under a completely different system than privately owned housing. So now I am missing people. Are we going to call randomly? 23-story new luxury apartment building in Tribeca built in 2006. Is it rent stabilized or not? Chat box. Maya, unmute yourself.
Hi.
Hi. Okay, Maya, if I do this correctly from now on, who loses a point, who gains a point for your other borough? I see that you're representing Brooklyn.
Yeah, Manhattan's gonna lose a point.
Oh, wow. Everyone's either pro or anti-Manhattan. All right. So what's the answer to this question?
It's not rent stabilized. Oh, sorry.
It's not rent stabilized.
Because it was built too recently.
It was built too recently. Probably, but I'm actually going to take the point back because we don't really know. You know why? They could have chosen to enter their apartment into rent stable. The answer is we need more info. Technically, it is possible that this building is a rent stabilized building because the landlord voluntarily opted into the 421A program, like we talked about, or the J51 for repairs. And they wouldn't really have to rent stabilize at a low rent, but they could be rent stabilized tenants from 2006. So thank you. I'm making it a very competitive game here, but the answer truly to this is I don't know. And it's getting more complicated as we go. So now, rent stabilized building sold to a new landlord who specializes in converting to high-end rentals and co-op. So you're living in this building and suddenly you find out a person bought the building who wants to convert it someday to a high-end co-op. Uh-oh. Who's the next person? I hope I'm not scaring people away by the other points. So Jody, can you answer this one?
That's why I was like, we need the option probably.
Yeah, so that's what we need more info. Do you know yes or no, or do you need more info with this one? So just to be clear, rent stabilized building, it's a rent stabilized building, and then a new owner comes in with the intention of converting to a co-op or condo.
I mean, I would tell the tenants, I think it probably is, but let's get your rent histories to start off. So I guess I would say need more info.
Okay. Yeah, this is one where, honestly, I think, Jessica, I'm going to let you be the arbiter of this. Is this a yes or is this an I need more info?
I'm gonna give her a point. I would say it's a yes. My answer would probably be yes, but it's always needs more info, honestly.
Yeah, I think the goal, I'm going to give this because I think, but I'm not going to take anyone away from this. Who are you representing, by the way? Jody?
I live in Brooklyn.
All right, so I'm going to give Brooklyn. I'm not going to take away. I'm doing a horrible job of counting. I need to pass that on to somebody else next year. The answer I had was yes. I think the needs more info could probably be applied to a lot of things, but the intention of the landlord oftentimes scares people. Like I know Extel, which built that horrible 57th Street building that goes up like 100 stories or something, or practically 100 stories. They're a crazy developer. They bought a building very near where I live, and the people in the building freaked out because they said, "Oh my gosh, we know what they're about." But the change in ownership of a building doesn't change the rent regulation status. So being sold to a different owner is never a threat to the tenants living in that apartment, because that doesn't get you out of rent regulation laws, no matter what the intention of the new landlord is. So now, is this specific apartment rent stabilized or not? I'm going to start grabbing somebody who hasn't spoken yet. I'm just going to randomly pick Julia. Can I make you be the representative for this?
Sure.
All right.
Okay, so
the tenant has a Section 8 voucher. That means they pay 30% of their household income towards rent. By the way, Julia, who's your favorite borough? Who's your least favorite borough?
I'm in Brooklyn.
Okay.
And I will, I feel bad. I'll hate on Manhattan.
Okay, fair enough. They drive up the rents generally when people move.
And it doesn't matter whether or not the tenant, I guess you'd need more information. Like, this doesn't tell you anything.
All right, you're absolutely right. You don't really know anything based on the voucher, as we talked about. The voucher doesn't indicate the type of apartment, and that's pretty critical. Tenants sometimes miss that point, but you don't know what the apartment is just because somebody has a voucher. So thank you. And I think this is the last question. This is probably the trickiest question we have. We've had a lot of tricky questions, but a tenant moves into a rent-stabilized apartment, and the tenant in a rent-stabilized apartment was paying $937.04. They move out in March 2020, not too long ago. The landlord offers the apartment to a new tenant, and the lease says in bold type at the top, in exchange for 6 months of free rent, the tenant agrees that this apartment is deregulated, not subject to rent stabilization. The tenant agrees to this, signs the lease, and they get the free rent that they were promised. This is a really complicated question, but you can do it. Am I going to pick one more person? How about Shanae? Can I pick you, Shanae? Hi, Shanae.
Hi.
Hi. Do you want to take a stab at this complicated question?
Not really.
Okay. Shanae, I'm going to just so that we can move on, I'm going to force you to pick the person on the list of people, and that person will have to answer, just so we can move on.
Janine Williams.
All right, Janine. Hi, Janine. No harsh feelings if you get it right, if you don't get it right, but I want to just ask you, do you think this apartment is a rent-stabilized apartment? Is it a yes, no, or a maybe? Okay, I'm losing everyone because I'm a little bit freaking out. So you know what? One person threw it out in there, and it was Jody was the first one. Jody, what's the borough you represent? Because you guys are going to get the point.
Brooklyn.
Brooklyn. All right, so Brooklyn does get to say that they're the coolest borough because they only lost a point. But y'all had way too many people at this training, but that's awesome.
They're way overrepresented.
Yeah, they were a little overrepresented, and you do have a Manhattan hating problem, I've noticed. But you guys did get the most number of points. Thank you for volunteering. The answer to this is that, yeah, this is a rent-stabilized apartment.
It is.
And it's going to be a pretty inexpensive one relative to New York City. So here's the thing. A landlord offers in the lease that there's 6 months of free rent if you agree to be not rent stabilized. we get the question sometimes, if you sign the lease and you agree to terms, right? Aren't you agreeing that the apartment is not rent stabilized? Actually, it's not up to the tenant or the landlord. You can't contractually make an agreement that overrides what the state law is. So the landlord and the tenant, for example, cannot in this case say, well, I'm agreeing that we're not going to be rent stabilized. Doesn't matter. That tenant paying whatever, $4,000 a month after the 6 months of free rent, they can say, actually, I'm going to challenge the legal rent, file a rent overcharge, and get an apartment that's only $1,000 a month. Forget those 6 months of free rent. And they would win because the apartment doesn't get deregulated through a decision of either the tenant or the landlord, even if the two are in agreement. Here's a really common one. Sometimes landlords say, look, you guys are going to agree that you're responsible for extermination and, you have to handle your own repairs. Actually, the law says that landlords have to repair their things for tenants. So it doesn't matter what your lease says. And they certainly can't rent you an apartment and say, I'm not going to give you heat. They don't necessarily have to pay for the heat, but they definitely have to give you the options. So Brooklyn, give you guys a little shout out and then go to some Manhattan therapy because I know y'all go into Manhattan on a regular basis. So back to the presentation, I'm going to just give a couple of tips for folks who want to know if the apartment is rent stabilized. If you're talking to a tenant, one of the best tricks is to ask them for their exact rent. So when I was in housing court, I would frequently ask a person, what's your rent? And they'd say something like, oh, it's $1,200. And a really great way of quickly finding the heart of the person you're talking to, say on the phone, or you don't have much time, is say, is it really $1,200 exactly? Or is it something like maybe, close to $1,200, $1,000, actually I blocked my own screen. $1,193.64. The reason why that helps is because a landlord would never invent the rent of $1,193. That makes no sense. They're getting the most they can get. And if that's what the legal maximum is, then you're going to end up with a weird number. But for the most part, market rate apartments are $1,200, $1,300, $1,350, stuff like that. Other thing is just, when you see an apartment, a building with 6 apartments built before 1974, don't accept that the apartment is market rate until you understand why. That's why this quiz is kind of keep it in the back of your head. Lots of times when I ask tenants in a housing court, when I was there, I would say, are you rent stabilized? And I know they don't necessarily know the answer, but a lot of them would say no. And the reason they said no is because the apartment was too expensive for them. They couldn't afford it. And so they would say no, but if you go harder into it, maybe they actually are. So, don't trust what a tenant says because they may not quite understand what rent stabilization is. And definitely don't trust the landlords because, they definitely don't believe the hype that they tell you. So now we're going to go into an address of the $1,300 apartment is probably the person living right across the hall from you. They just don't want to tell you. To Robert. So evictions. You can be evicted from a rent stabilized apartment despite what landlords say. Frequently the New York Post puts out articles, it seems like almost every month, saying that rent stabilized tenants can't be evicted for anything. You can definitely be evicted for non-payment of rent. Absolutely. There's no tenant category in New York that you can have not paying rent and you get to stay in the apartment. The other ones is you can be evicted for violating a substantial obligation of your lease or of rent regulation laws, which is usually what comes up. Illegally subletting is big, but the biggest of all that I see is non-primary residency. They allege that you don't live in the apartment as your primary residence. You really live somewhere else and you just pay rent at this apartment for fun. All they need really to start that kind of case is somebody with the same name as you that lives somewhere else in the world. They can say, oh, I see this other person whose name is Dulcie Frederick, and Dulcie Frederick lives in Jamaica, and that's really you. and they force you to go to court to do that. It's a really messed up thing, but basically you do have to live in it as your primary residence. Now, being a nuisance, they can allege that you are a clutterer, that you have threatened the super, that you pay rent late on a regular basis, including that you get brought to court on a frequent basis. And all of those things are basis of eviction. But you know what's harder about the nuisance ones is they have to kind of prove it. All of these you have to prove. You can't just make the allegation and then say go. And nuisance ones, you know, are a little bit harder because it's a little bit more of like a law and order kind of thing. But these are all things that the landlord needs to go and prove in court. There's a handful of others that are really complex. Owner use means the landlord wants to either move in themselves or move a family member into your apartment. That used to be easier. The new laws made it a little harder for landlords to do that, but it is technically something that they can use as a basis of telling you to leave. If they say they're gonna, now, that's only good for people. If your landlord is a person, if your landlord is a company, companies don't have cousins or children. And that means that companies are not allowed to use the owner use thing, only if the landlord is an actual person, not a corporation. Things like, I want to demolish your building or I want to convert it to a non-residential building. And that doesn't mean, you know, I want to convert to co-op. We mean like, I want to turn your building, instead of being an apartment building, into an office building. Those are extremely complicated for a landlord to prove in court, because the courts look very skeptically on landlords alleging that, because they know landlords are sometimes trying to cheat the laws. So if you ever end up in a situation like that, you need to fight it. Lawyers will generally represent tenants for free if they have the other qualifications that they meet in those cases, because, you know, they don't want landlords to get away with just saying, I plan on demolishing the building, emptying out it, and then renting to new people. Now, you cannot obviously be evicted because market rents are higher and the landlord says they can get a higher rent. They definitely cannot kick you out because you've complained about services or repairs. And if you file a rent overcharge and you lose, turns out you were paying the legal rent, they can't say, oh, well, you know, you were trying to go after me. No, you have a right to challenge the rent. They obviously can't evict you because the lease expired and because they hate you, because we know they hate you already, and that's not a basis for eviction. Now, succession rights. If the primary tenant moves or dies, this is huge. Household members that have been living in the apartment might have the right to take it over at the same rent level. So your grandmother's $271 apartment, you get to actually keep that apartment if you were living with grandma. There's two criteria. One is that you must be an immediate family member of the primary tenant, except that has actually been really successfully broadened in the courts to include what they call a non-traditional family member. They originally came up with the non-traditional family member, from what I understand, at a period where there was no legal recognition of same-sex partners. Because before the government was recognizing those kinds of partnerships, you were all but a spouse, but you weren't recognized under the law that way. So they started creating a category called non-traditional family members. And if you can establish that that was what your relationship was, you're entitled to succession too. And over the years, they've expanded it to now people who say, well, you know, this is my uncle, and uncles and cousins are not immediate families, or sorry, uncles and nephews are not immediate family members. They wouldn't otherwise count, but this uncle raised me since I was a little kid, and he's really like a father to me. That actually counts, but you have to show that the relationship is not a roommate type relationship. It's not that you just split the rent and 50-50 and live independent lives. You live a family-like intermingled life. Financially and emotionally are the keys. The second piece is that you have to have lived in the apartment for the prior 2 years. Now, if you're 62 or over, it only is a 1-year requirement, but that would be for the person taking over the apartment, the 62. So the 2-year rule means that, unfortunately, if you've lived in that apartment for the first 57 years of your life, and when you're 57 years old, you finally go out and get your own apartment, and the next day something happens to your parents, they pass away, you don't get to take over the apartment. It's not your home anymore. But if you moved out and you haven't lived in the apartment for 30 years, but you move back and you've lived there for 2 years, and then suddenly something happens, you do get succession rights because you've been living there for the last 2 years. It's only the most 2 recent years that counts. The way that you establish succession rights is proving those 2 criteria. You can't prove that ahead of time. You can't prove that you've been living somewhere for the prior 2 years before someone dies or moves until they either pass away or they move. So there's no such thing as a, pre-registration for succession rights. All you really need to be doing is make sure that the apartment that you're living in, if that's where you live, that's where it says on your document. So if you have kids going to a public school and you're registering them in a different apartment, that could be compromising your succession claims. It might get them into a better school, but it could harm your ability to take over the apartment. Same thing with car registrations. People love registering their cars in other cities or even other states because the insurance is less. Well, that's can potentially compromise your succession claim, because when that occurs and you're in court, the landlord might say, I see that you register a car in Vermont, so I guess you live in Vermont. That's what you said when you were registering your car. So the tip is just, it's not worth it. Register the apartment that you live in as the one that you is your primary residence, and you shouldn't have trouble, except that you have to realize landlords basically reject almost all succession claims, no matter how obvious they are, because these are people paying low rents that they can't manipulate. They know what the rent used to be, and they may want to live in that apartment for decades to come. So because of that, landlords oftentimes reject every succession claim. I met one person once who basically never lived anywhere else. He grew up in the apartment. He didn't even move away for college. He lived there his entire life. His parents passed away. They challenged his rent. The landlord knows that the succession claim, the landlord knows that the person lives there. They're just hoping that he's going to be intimidated to not go to court. So when you're in this kind of a case, try to find a lawyer. This is what the legal service providers specialize in, and don't let the landlord scare you into leaving the apartment.
Mario.
Yeah.
There's a couple of scenarios in the chats about succession, and succession is like a topic that we could do a whole 3-hour training specifically about, but I don't know if you just want to mention these 2 scenarios that are in the chat.
Yeah, let's do it. I'd like to hear it from the person themselves. Can you unmute one of the people that asked the question?
So the first question came from Damali, and the second question came from Kim.
All right. Either of you two, do you want to just unmute yourself and ask the question to all of us?
Yeah,
Okay.
I can talk. Oh.
Go ahead.
So if you have a child, if you're living with a child and you live in a rent stabilized apartment, and let's say you put them on the lease, can they take over the apartment when they're an adult?
Yeah, so that's actually a 2-part question. It's an excellent question. Thank you so much. The answer is 2 things. First, I want to say you mentioned put on the lease. In succession, it's not necessary to be on the lease. They don't even need to know that you exist. If your name is on the lease and you're what they call a co-tenant, so say you and your daughter are on a lease, right? You rented the apartment together and both of your names are listed as the people who are the leaseholders. Both of you are already on the lease. And if one of you were to leave the apartment or something happened to you, the other person, all they need to do is tell the landlord, actually, this other person left, I'm still here, and you don't need to go through succession. Because you were already on the lease to begin with. All you're doing is removing a name from the lease. So that's just one thing I wanted to say first. Now, the question about a person who is a minor and they're under 18, and say the people that they live with, if they're their parents or their foster parents or anyone passes away, and suddenly you have a minor in the apartment who has succession rights. Yes, minors are allowed to succeed apartments. It's a little more complicated because they're not supposed to legally be in the apartment on their own and be on the lease. So what usually happens is that in some case, in these cases, a guardian is appointed for that person. And if the guardian lives in the apartment with that person in order to give them the ability to be autonomous, I don't know at what age the courts allow you to be autonomous, living autonomously and recognizing this, but the child does have succession rights at that point, and the only complicating factor is the fact that they're underage. You know, so say they were 11 years old, they can succeed the apartment. They probably need somebody who's a guardian to move in there with them, but that does happen. That actually happens frequently.
Can I ask another follow-up question, or maybe I can ask later
Sure.
on? Okay. So let's say you're sharing custody with the minor. Is there a limit on how the percentage of time that they could that they should be living in that rent stabilized apartment?
You mean somebody who's not on the wait, I want to rephrase the question slightly. So you're saying if somebody is not a family member and they want to be in the apartment, is there a maximum amount of time that they should be allowed to live there before something is being done wrong? Is that what you're saying?
No. So let's say you have a child and you share custody with that child.
I see.
Can the child still lives there part-time?
Got it.
Can
Got
that
it. Okay, so a lot of this is now you're getting into the area where it starts to become kind of a tricky legal thing, but the answer I would give is that it always comes down to primary residence. The concept of primary residence hinges on that somewhere is your primary residence. You can't have multiple primary residencies. So with all sorts of legal cases, whether it's succession, whether it's non-primary residency, that's the case where they say that you don't live in the apartment. What ends up happening in the court case is people are in an argument over whether or not that is really where you live primarily. So say, for example, you have a summer home. The landlord might want to claim your New York City apartment is not really your primary home. It's this place in, you know, out in the mountains in Maine. And you're like, yeah, well, actually, that's just my summer home. I'm allowed to have a summer home. That's not my primary residency. You get into a dispute about whether it is or isn't. And sometimes you can make it easy, like saying, actually, that's just a shack and it doesn't even have insulation, so it's freezing in the middle of the winter. Obviously, I don't live there all year long. Other times it can be more complicated, you know, and it can go down to evidentiary things that are very specific to the person. So it comes down to primary residence. Nobody should give you a straight answer in any case, but they always determine it. So, you know, right, I think it was earlier this year, or maybe a year ago, Donald Trump decided to make Florida his primary residence and New York not anymore, which I was totally fine with. Thank God he's not a New Yorker anymore, but in my opinion. But now that means that legally speaking, he's saying, I declare Florida as my residence. He's probably doing it for tax reasons. People do it for all sorts of other reasons. In a rent stabilized situation, there has to be one or the other. You can't have multiple primaries. And you can't, it's not what you say it is, it's what the facts show. If I say I have a non-primary, I have a primary residence, but then in reality, the facts show otherwise, it doesn't matter what I say. It matters what the facts say. And the same thing with the non-traditional family member. If I'm really a roommate and I really don't know this person like that, they're not a family member type, I can call them a non-traditional family member of me and try to claim succession. But the landlord can just as easily prove it and say, I don't see you guys ever doing anything other than sharing housing expenses. This person doesn't list you in their will. You guys don't, you know, have a shared bank account. You went to a wedding, you didn't even invite them. If they're really a family member, wouldn't you have gone together? I mean, it's a complicated thing, and it's the facts, not what you call it, that determine it. But sorry, that's a long answer, but it's a really important sort of series of questions that get to the heart of what rent stabilization hinges on. I think there was another really good question too. I'm gonna go through just to, since we've gotten a bunch of questions lately, and say preferential rents, yes, we're gonna cover that. We're actually getting pretty close to the end. So it should be in just a few minutes. And let's see.
There was a succession case about having a live-in boyfriend or girlfriend.
Yeah, the live-in boyfriend or girlfriend. Yeah, a lot of people decide not to get married, and that's totally fine. If you're really nervous about it, it's never a bad idea to go through the legalities of establishing that you're, a domestic partner, if that's what you want to do. But there's no obligation that you have a legally binding relationship. If you have the emotional and financial part, a long-term boyfriend or girlfriend would count. You just have to kind of refer to them in this case as a spouse. Like, we did everything other than get married. We lived together for 8 years, and there's no difference between how we lived and how a married couple lived. That's totally fine.
Can I just interject just a minute? I apologize. Quickly on that, if the person just passed away, does that still apply? I believe that they were dependent on each other financially. I'm not sure about what was in the lease, but definitely they were dependent on each other financially. I don't know whose name was on the lease or who was more financially responsible, but you're saying as long as they lived together for decades, that he would actually have the succession rights.
Yeah, so basically I'm going to go back to the slide, and this is what you have to prove if you're not on the lease. That you are an immediate family member and you lived there for the prior 2 years. So this is definitely one of those, like, screenshot this kind of a slide and refer to it, because all you're proving is that these two are true. The nuances are about whether or not this is true, fundamentally. Did you really live there the prior 2 years? Or 1 year if the person asking for succession is over 62? And are you really an immediate family member or a non-traditional family member? That's it. You're just proving whether those are true or not. And that's the only question that really matters. So again, you've mentioned the word lease, and if your name is on the lease and one of the two leaseholders or multiple leaseholders leaves, everyone who's named on the lease doesn't need to go through this process. They already have rights to the apartment, and it doesn't change whatsoever when someone leaves. We're only talking about cases right here where somebody living in the apartment wasn't on the lease and they want to take it over. And those are the people who have to go through a succession claim. And just to be clear about how that succession, I'm going to jump to the next slides regarding this. Oh, did I take those out? I might have taken them out. What you do to assert a succession claim is you literally just write a letter to your landlord. You can write him a letter and keep a copy of it, or you can write an email and keep a copy of the email. And what you're asking the landlord to do is say, hey, I don't know if you know me or not, but I'm the son of this person. Now, don't forget, they don't have to die. They could have moved away. It doesn't have to be a death. It could just be that the person who lived in the apartment leaves. So in that case, you say, look, this person left. I'm their son. I'd like to take over the apartment, and I'm letting you know that this is my succession claim. You can offer information, but I wouldn't offer very much. I would just offer who you are in terms of the relationship and say, I've been living here for more than 2 years. The landlord can come back to you and say, great, I'll add your name to the lease next time it's renewed. Done. You've already succeeded the apartment. Nobody needed to go to court. That happens, particularly if the landlord knows that you really have rights, that you know what those rights are and that you're going to fight for them. But if the landlord thinks you're vulnerable, the landlord might say, okay, prove to me that this is true, and start asking you for a bunch of documents. And once they start asking you for documents that go beyond something basic, that's when you need to talk to an advocate and potentially a lawyer, because what they're trying to do, probably, once they've gotten enough information to see that you are eligible, if they keep asking more and more, let me see your bank account. Really? Okay, let me see your credit card statements. Okay. Now they're fishing for information that's going to weaken your claim, even if it's a valid claim. And that's the kind of thing they'd be doing in court. And you might be better off working with a lawyer who's going to tell you, you know what, let them bring you to court. Let's not engage in this back and forth. You're just giving them more time to make a case. They're planning on bringing you to court anyway. Let's let them do so, and we'll fight it out in front of a judge. So at some point, you do have to kind of decide, you know what? Let them try to evict me. Unfortunately, there's no court case in housing court called succession. There's also no court case in housing court called overcharge. These are things that you have to let the landlord try to sue you for, basically saying, I want you out, right? You don't belong in the apartment. I don't recognize your rights. And then you have to go in front of a judge and say, actually, here's why I'm still living there. I'm entitled to succession. For overcharge, I decided to stop paying my rent. And the reason why is because I want to say that the rent is being charged as too much, right? And then you raise these as defenses. But all of these things are the kind of things that you need to do with a lawyer whenever possible, because there's pitfalls, there's ways that you can damage your own claims by going about it the wrong way.
Can I just add one thing?
Yeah, of course.
The laws on succession rights and the case law that has been decided about succession rights is really good for tenants, and the law, it's expansive, and if it really is your apartment and it really was a family-like relationship, it can be pretty easy to win. So the DHCR on their website has a ton of information and fact sheets, and they do have specifically about succession rights with scenarios. And as Robert Tilley put in the chat, they have a form you can fill out to make a claim for succession rights, which is just another piece of evidence that you would use. But definitely, if you're talking to someone who's in a situation that you're not really sure about, or not, you know, doesn't seem like there's a lot of evidence, talk to someone, because I've seen people win succession claims with very small amounts of evidence, with relationships that seem like maybe they wouldn't qualify. It's a place where tenants really can win in the law. So I encourage people to fight hard on that one if that's what's happening for them.
Absolutely.
Also, there was recently, earlier this year, Home Health Aid won succession rights, which was an unprecedented court case. She had been living with Home Health Aid generally is considered an employee, and so they wouldn't qualify for succession rights. But this was a case in Brooklyn where the Home Health Aid had been living with the woman for, I think, 20 years as her primary residence. And there had been times when she wasn't paid because the woman didn't have money to pay her, and she stayed and she kept taking care of the woman, and she won, and she got an apartment that was like $500 a month. So
that's amazing.
Fight hard,
but those are outliers, and I just want to be clear about what the law says technically. Technically, the reason why that's a noteworthy thing is because it's not the norm. The caregiver situation. Normally, as Jessica said, a caregiver would be treated as an employee, and that wouldn't meet the criteria of immediate family member. And generally speaking, roommates don't fit it either. Like, even if you're a long-term roommate, if what you did is rent a room, that's not meeting the criteria. But I wouldn't decide that you're going to lose before talking to somebody, and there's no harm in fighting it, really. I mean, when I say no harm, you do have to go to court. You could potentially be named on the court case and lose and end up on what they call the tenant blacklist. And unfortunately, that's a risk that you might have to take. Hopefully you never get affected by that because you win the case. But I would always do these things with as much help from an expert as possible. And I would always fight if you have a fighting chance. I would never give up. You know, the answer to somebody who says, well, what if I lose? Okay, well, what's the impact if you lose? The effect is that you have to move out of the apartment, right? Why would you do that? Why would you do that to yourself? Let a judge do that. You know, if you have a claim in court that you're not sure you're going to win on, they're going to be making you pay the rent the whole time. You'll still be living there. You can plan for the worst. But if the worst outcome is that you lose the apartment, don't give yourself the worst outcome by moving out of the apartment, right? There's no like execution chamber in housing court. If you lose the case, losing the case means you have to move out of the apartment. So don't ever do that to yourself. That's kind of a motivational thing, but people in court think like, oh my gosh, I'm being accused of something. You're not being accused of a crime. You're not going to go to jail if you lose. You're going to lose your apartment in an eviction case. So fight for it. You know, the city has tons of really terrific advocacy groups doing it, doing the kind of eviction prevention work. I'm going to jump on to the next thing and just go through the deregulation piece. And thank you for the super sweet comments. I saw a couple very nice things on the Zoom chat. So Jessica and I really appreciate that. I think we both care about these things deeply, and I'm glad it's reflected. I want to go into deregulation just a bit more than I did before, because as we talked about in the 1990s, we almost lost rent regulation at once. Deregulation began in 1993 at the city council, and then it moved to the state in 1997 and was codified in the state law. And the way they were able to get this is that landlords had basically given enough money to enough elected officials that they had kind of control over a majority of the elected officials in the state Senate, who then said, we're just going to end rent regulation at once. And the rent stabilization law basically created deregulation as the, again, compromise. Landlords wanted to get rid of rent regulation completely. Tenants wanted to keep it and strengthen it. And so what they ended up, because landlords had the upper hand at that time, was that they said, if you can pass a certain rent threshold, the apartment is deregulated. If it's below that threshold, it stays rent stabilized. We could spend a whole 2 hours on this, but thankfully the laws changed in 2019, and we don't have a situation of deregulation. So I don't want to go through that very much. I just want to point out that the laws changed over the years. So for the first chunk of time from 1993 to 2011, you could deregulate the apartment once the threshold of 2,000 was crossed, and then it became 2,500, and then that number became 2,700. And once the apartment has left the rent stabilization system, any rent can be charged at all. Now, the legality of doing that is not, oh, I found a tenant who's willing to pay more than this number. The legality of it is I used the IAIs, I used the MCIs, I used the eviction bonus called vacancy bonus. I used all of the legal means to get the rent above that dollar amount, whether it was 2,000, 2,700. As soon as I crossed that threshold, the landlord at that point can say, okay, I'm no longer subject to rent stabilization. I can charge any rent. That's the reason why New York City rents became so outrageously expensive, is because apartments were leaving the system rapidly over the course of 25 years. But because it was done illegally, potentially, at many cases, and the landlord just hoped that the next tenant wasn't paying attention, it's always worth taking a look. Find an advocate or a lawyer if you have a complicated rent history. Don't assume that they moved it out. And then also, the rent it's being charged is not the guiding number, because an apartment that rents for $1,800, if it was deregulated, well, actually, once you're deregulated, they don't tell you you have to charge more than 2,000 or you have to charge 2,700. You can charge whatever you want. You can charge less than what the law says. You can charge more. It just means that nobody is telling you what the rent has to be. Lease renewals, we're going to go through this pretty quick, but a lease renewal is an entitlement for a rent stabilized tenant. But if the landlord says, I'm not offering a renewal to you, I would actually say, that's great, because the only thing that happens with a rent renewal is my rent goes up. So by not getting a lease, that just means that your current rent stays the same. You have no fear of being evicted. It's not grounds for an eviction for a landlord. So you haven't lost out on anything. This is a tricky one. Sometimes when people apply for programs like FEPS, a one-shot deal, the people at HRA say, well, you know, you need a lease in order, you need a current lease that has at least a certain number of months before we're going to give you the one-shot deal or the FEPS application. The reason they're doing that is they don't want to give the application to somebody, they don't want to give people back rent, and then that person the next month gets evicted. But in a rent stabilized apartment, that's not a real legitimate fear, because you have the right to live there as long as you want. So if you get rejected for a one-shot or a FEPS application or any rental subsidy based on the lack of a lease, you need to talk to a supervisor, because they usually understand that those are not requirements in a rent stabilized apartment. If the landlord tries to backdate a lease or alter the terms of it, you should photocopy it, return it to them. I always recommend sending it certified mail so that you can prove that you showed that you brought this to their attention. and just tell them, you know, you're trying to trick me. This is not right. I'm going to reject this lease for now, but I definitely want to keep the apartment. So please send me a correct lease, and you're not running a risk. It's just something you need to document. Make sure that you do say that you really wanted to stay in the apartment. Now, if you're married to somebody after you move in, or maybe you didn't announce it before, you can always ask your landlord to add a spouse's name to the lease. But they have to say, okay, that's something in the law. But if you ask them to add anyone else, including an immediate family member, the landlord is not really required to add that person's name to the lease. They might choose to agree to it, but they usually don't, and the landlord doesn't really have to tell you why. The reason why is that they probably want you out because all of your family members know that you're paying a lower rent, and they want to get a new tenant in who doesn't know their rights. And for that reason, they oftentimes reject it. But you're allowed to live with whoever it is that you want as a family member. And you're also, if you're the only person named on the lease, you have the right to one roommate. I'm going to touch on that briefly on the last slide. But basically, they may tell you no. But when you're renewing your lease, this is the moment that it's really important that if a person who was on the lease originally, whether they were the only person or whether they shared it with someone, that they remove themselves from the lease. The reason why is that succession rules require that you declare this to your landlord soon. If you wait and don't mention succession, or you don't mention that someone who's moved out or died that no longer lives there, and then wait until later and the landlord finds out first, the landlord can say, you were trying to defraud me. You had the lease signed under the name of somebody who doesn't even live there anymore. And now you're a defendant in a case like a non-primary where you should have had rights, but you kind of sat on them, and it becomes way more complicated. So that's the moment. You should always be honest. Don't be afraid of going to court. If you are in the right, court is there for you to exercise your rights. If you try to hide something from the landlord, you may be compromising your claim long-term. So one of the last topics we're going to talk about is preferential rent. That means that you're paying less than what the landlord's registering as the legal maximum rent for a rent-stabilized apartment, for your rent-stabilized apartment. Here's what it looks like. How many of you guys have seen, well, you're not raising your hands because most of you are not on video, but oh, there we go. Yay. If you've seen, anybody seen this? This is like the standard rent stabilized lease renewal. If you look carefully on this, you'll see here's what the legal registered rent is for your rent stabilized apartment. Here's the percentage increase that they want to increase your apartment for. And here's what the new rent will be when you sign your lease. So they'll give you, for example, here's if you renewed it for 1 year, here's if you renewed it for 2 years. A preferential rent shows up down here as a lower amount that they're charging you. And that's usually through the first lease. If they're saying, hey, you know, I'm going to move you in, it's only going to be $1,100, but I'm going to register with the HCR a higher rent. You only have to pay the $1,100. That's what they call a preferential rent. In the dark days, preferential rents were considered temporary, and the landlord was allowed to jump to the higher legal rent. It allowed them to really trick tenants and turn over apartments rapidly. Thankfully, and by the way, that was super shady, so they get the broken umbrella treatment. But under the new system, preferential rents are a permanent fixture of the current tenant. So if they gave you a less rent than they registered it for, you get to keep that rent as your rent in that apartment as long as you are the person living there or your successors. And they have to apply the Rent Guidelines Board increases to the lower amount. This is a huge, huge improvement from what the laws were before. What was happening under the old law is that landlords were registering a very high rent, renting it to people for a lower amount, and oftentimes illegally registering something that was way higher than the law actually permitted, but they knew that people wouldn't challenge it if they weren't paying that amount. And then after a certain time period, which was 4 years, they basically got away with it and were allowed to raise the rent without fear that the tenant would challenge it because the statute of limitations was up. So that is no longer the case. We now have a situation where if you rent an apartment for a certain amount and they say that the legal rent is higher, you're not anymore at risk of paying that higher amount. But I still recommend people get their rent histories and challenge it because A, the landlords might be getting away with fraud. You're helping the next tenant if you ever move out. Well, that's actually the main reason right now. You're helping the next person. There are certain minor surcharges like air conditioners and washing machines that you sometimes see that landlords can charge you for. So just to let you know, those are actual real things. There's also adjustments can be made if they used to have what they call a master meter and they now individually meter your electricity. That's kind of rare. Landlords definitely have to accept subsidies. There's no way they can reject a tenant who has that. And what's cool is that since you already live in the apartment, you don't have to shop for an apartment. If you've been waiting for a Section 8 voucher for 7 years and you finally get one, you just present it to your landlord and they can't refuse it. And then the last thing is that you see the right to a roommate. We talked about this. That's a state law actually, but it's important to talk about in rent stabilized apartments because your ability to pay for an apartment is oftentimes because you have someone else living with you. And the way that the roommate law works is that if you are the only person listed on the lease, you're allowed to live with one other person and their dependents. And the person who lives with you can only pay up to half of your rent. That's the maximum that they're allowed to be charged. If you charge more than half to your roommate, it is a form of overcharge and is not a situation that any of us endorse, and you should avoid that because the rent stabilization law basically is trying to keep rents low for tenants, but also they feel that that's disadvantaging the landlord and that you're kind of taking advantage of the law. So the courts look down on that behavior very strongly. There's some cool programs you guys probably already know about, which is SCREE and DREE. SCREE and DREE. SCREE is for people who are seniors. DREE is for people who have a disability, and you have to be on some form of government disability program to show your eligibility. But what it does is it freezes your rent at whatever you're paying when you join the program, as long as you're paying over a third of your income in rent and your income is less than $50,000. And what happens is that every year as the increases for your apartment are applied, the city covers that through a tax breaks to the landlord. So your rent actually stops going up. And a lot of seniors are able to live in their apartments because of SCREE, and same with people for DREE, because of this. So even though the rent keeps on going up, your income is fixed, you know that you're going to be able to keep the apartment. They do not make SCREE available to market rate tenants for a really obvious reason. The obvious reason is that if the government says we're going to pay all your future rent increases, the landlords that were charging $1,500 are going to say, oh, really? The government's going to pay for it? Okay, then it's suddenly a $50,000 a month apartment. And the government has no control over what the rent is. So they only offer these rent freeze programs to people in rent stabilized apartments. And that's another reason why rent stabilization is just kind of core to the ability of the city to manage, you know, all sorts of assistance and housing for people of all ages and all categories. It's not a perfect system, but it is definitely better than being in a situation where the landlord is getting to charge you whatever they want and can evict you whenever they want. So that's the end of this presentation. And what I have here is just a couple of the referrals to different sites. Housing Court Answers has a hotline that's open 9 to 5. I think you guys are very different under coronavirus right now, but
we're open on
Tuesday,
Mondays
Wednesday,
and Fridays
Thursday?
too. We're open
Okay.
every day, Monday to
Oh my
Friday,
gosh.
9 to 5, taking calls. Eagerly awaiting our calls.
All right. Now, I want to thank everybody for being a part of it. I'm not going to go anywhere. I'm going to stay on for questions and answers, and I don't have any time limit whatsoever. At a certain point, we'll turn it into a happy hour, but I will hang out for as long as anybody wants. But for those of you that want to leave, I want to thank you for doing it. For everybody who participated in the rent stabilized or not, whether you got the point, whether you gave the point away, thank you so much. I hope I didn't trick you or embarrass you at all if you didn't get the point right, but I really, really appreciate everybody for participating. And
Mario, I want to know what prizes did you bring for the winners of that game?
Oh, for Brooklyn? I was gonna make a donation actually because to a charity of the winning organization. So if anybody from Brooklyn wants to throw out what kind of a charity, I'm gonna make a $25 donation to whatever charity that you want to help people out. Particularly, I'd love to see it be a housing organization. So if it's one that you want to do, that's gonna be the gift. I can't give anything away. So equality for Flatbush. All right, send a link so that we all can do it. Actually, that might be a nice thing to do. Jody, I'll take yours if you're one of the people and you said it first. So just shoot a link out on the chat box. Anybody else that wants to put a chat box suggestion for a donation, or just to shout out to the community organization that you fight for or fight with, it's helping tenants, whether it's a donation or just to let people know about it, that'd be awesome.
I have a question.
Yeah.
Okay, so for the program Screen and Dream.
By the way, thank you to everybody leaving, and thank you for the nice comments. They help so much. So go ahead, Elizabeth. And by the way, if you want to queue up for questions, I'm going to start scrolling up, but a lot have come in recently, and I'm going to think that if you had a question that wasn't answered because I skipped over it, put it back again, and then I'm going to start going down the chat box in terms of managing after Elizabeth.
Okay, I did put it down. Okay, so a person is on DRE, is applying for DRE, and they have a minor. The parent is not on disability, but the minor is. Their name is not on the lease.
Okay.
Why can they apply for the program?
Well, both SCREE and DRE are looking at what the total household income is. So you actually have to include in both of those applications the income of all of the members of your household. And the eligibility for it is going to be, I don't know if that's the reason why they're not eligible or if they were denied.
They were denied.
They were denied. Yeah, it could be because they were counting the children's income and the adult's income. But I also believe, if this is not true, Jessica, I've never heard of the minor situation, but does the parent have to be the recipient of DRE in order for it, does the person on the lease have to be the DRE recipient? Or if they're the parent of somebody that's eligible otherwise?
I've never heard that one before. It has to be the tenant of record that would be eligible for DRE and SCREE. I don't think it's for other members of the household. I think the tenant of record would have to be eligible.
Right. Wow. I've never heard of the children one because I know that sometimes families have to take care of children. That's a really interesting one, but don't forget about the income threshold piece too.
Yeah, okay.
And it's interesting because that's when they count your household. It's very similar to what we were talking about earlier. You know, are you an immediate family member? Are you a non-traditional family member? And roommates actually don't have their incomes counted towards SCREE or any other of these programs. What they actually count is the income received from the roommate. So for example, if your roommate pays $500 a month for renting the room in your apartment, they don't count the roommate's total income as your household income. They count the $6,000 a year that you receive from your roommate as part of your income as the primary tenant. So it's kind of interesting.
Okay, thank you.
Yeah, thank you. All right, I'm going to start scrolling up, starting with, well, I think after the equality for Flatbush that Jody put in, I'm going to, yeah, so Jessica was pointing out that subsidized tenants can only have people living in a lease in their apartment. If you have some sort of a program, and DRE and SCREE would be among these, you need to be careful that you're not violating the rules of the program, even if you're following the rules of rent stabilization. So for things like, say you have Section 8, right? There's rules of rent stabilization that you can be following, but like, for example, your right to have a roommate or right to have family members live with you, that's no problem with rent stabilization. They may be people that you're supposed to be declaring on your Section 8 voucher, or that you're not even allowed to have in the first place based on, you know, what your income is, and you need to be very careful about that. That's absolutely a great point. Actually, I want to turn on the questions of people. So Wendy De Leon, do you want to ask the question you had?
I honestly can't remember the question right now.
This was about being the tenant of record, proving that you were responsible from the rent.
Oh yeah, no, my experience with SCREE and DREE, I work with families who have a household member with a developmental or intellectual disability. So typically, even if they're adults, they're not put down on the lease as a tenant of record or a co-tenant. So we typically encourage them to do that in order for them to apply for DREE. And the reasoning that I've been given is, as when you're listed as a tenant of record or co-tenant, it's proof that you are responsible for the rent. You know, and that's part of the issue with these programs. They're rental assistance to a certain extent. So you have to prove that you are responsible for some type of the rent in the apartment that you live in. If not, you'd just be an occupant. And with a minor child, none of their income, even if they're getting SSI, is technically supposed to go towards rent.
Great. That's yeah, right, because that's not form of income.
We know the reality of it is different, but technically, you know, that's the thought process.
No, that's really helpful. I really appreciate that. And it does kind of make sense in a certain point, because they have to find somebody responsible. But, you know, one of the points you were making about who's responsible for the rent, this is actually a really interesting point that I see come up for reasons that are really kind of shady again. Landlords sometimes asking you to prove what your income is when you're getting a lease renewal, or at other points where they say, well, show maybe a succession. Once you have the apartment under your name, not being able to document that you have enough money to afford it is not a grounds for not getting a lease renewal, nor is it grounds for denying succession. They don't have the right to say, I don't think you can afford this apartment anymore. They don't need to know how you're getting your money. Once you have the apartment, as long as you're paying the rent, that's all they need to know. Whether you're a street vendor that sells empanadas or whether you have a job on Wall Street is really not their business. Catherine, I'm trying to understand your question. Would SCREE or DREE apply in a situation where somebody has to make an overcharge claim? I don't think, Catherine, do you want to explain your question?
Well, yeah, sorry, I'll unmute. So my situation is complicated. I'm not allowed to ask questions about it, basically. I have a market rate lease and it should be stabilized, but because I have to prove that, it's like an uphill battle to document everything.
I see.
Yeah.
Okay, so the answer to,
sorry.
I'm sorry, you're trying to find out whether SCREE or DREE will apply until you've made your overcharge claim successful?
Well, yeah, it's just like they kind of always seem to get ahead of everything before I figured it out.
I see.
Yeah.
So I think the answer to that is that SCREE as a program relies on the recognition of your rent stabilization status. So if you're a person who was in an apartment that they say was illegally deregulated, they're not going to give you the benefits of SCREE or DREE until the court or DHCR has recognized your rent stabilization status, because it's a program requirement and they're not going to take your word for it. That said, you might have a benefit of still applying, because it might be able, I don't know this to be true, but you might be able to establish that the date of your request was now, because And then if it takes a year for them to, you know, recognize you as a rent stabilized tenant, then you may be able to say, well, you know, actually I asked back then and I was disadvantaged by my lying landlord. So I wouldn't stop you, but you probably won't be recognized until the courts or DHCR recognize you. I also had I noticed a really great question from Alyssa about income. I like the question. Can you ask it, Alyssa?
Sure. I was curious to know if your landlord found out I don't have a specific example, but if they found out that your source of income was illegal, if they would be allowed to legally deny a renewal of your lease.
Yeah, it's a really great question. The simple answer I'm going to say is no. That the source of your income is not a grounds for denying a lease renewal. And I'm going to go a little bit further than that in two ways. One of them is that there's actually a law in New York that's called source of income discrimination protection. I might be getting the name wrong, but it is a form of legal protection saying it's not the landlord's business how you can afford the rent if you can't afford it. But that law actually covers people only for legal sources of income. I wanted to point it out because I didn't mention it in this in the course of this presentation, but it's a good thing for people to know. The reason they created the law was to protect people who have vouchers so that a landlord can't say, you know, I don't really want a person with Section 8. Well, Section 8 is legal income. It's a legal means of paying your rent. If that helps you pay the rent and you're able to, they have to accept it. That law doesn't protect illegal forms of income. But now I'm going to go into the question about rent stabilization. So rent stabilization, once you have a lease under your name, they don't have to rent you the apartment. They have the right to put up criteria as long as it's non-discriminatory and it's not changed every tenant if it applies to every person. The landlord can set criteria for who they want as tenants that could require that you prove your income, and that's totally legal. But once you have an apartment and you just are renewing your lease, you don't need to answer any questions about what your income is, so the landlord shouldn't even know to begin with. But if they know that your source of income is some sort of an off-the-books, you know, thing that otherwise wouldn't be considered a legal form of income, I don't think it's their business, with one exception. If you're using your apartment illegally, and illegal would be, for example, I sell drugs out of my apartment, or I'm running, you know, I'm a sex worker and I use my apartment to bring my clients in. That kind of stuff actually fits within the nuisance law. But it relates to the use of your apartment. And it wouldn't be a denial of a lease renewal, it would be a nuisance holdover case. So they would bring a case in housing court for nuisance. But as I understand it, say you're a sex worker, but you don't work out of the apartment, you work somewhere else. I don't believe that that is grounds that they could say your source of income is illegal or you're doing illegal activity. They can't tell you that's a grounds for losing your apartment. Super interesting case. When I was at Met Council on Housing, we had a hotline too for tenants' rights. And I remember one day somebody called and they were trying to figure out, the landlord was trying to challenge their primary residency in their rent stabilized apartment because the person was in jail. And as it turns out, this has gone to courts, it's been appealed, and it's very straightforward. If you have a date at which you're going to be released, jail is not your new primary residence. It's a temporary residence. They treat it just like you were going away for college for a few years. So you're allowed to maintain your rent stabilized apartment while you're in jail and then come back and you get to keep the apartment under the old rent. So you don't lose your primary residency. I think you could probably assert that that's a valid reason to sublet your apartment. I'm going to be away in jail. So it's a longer answer than I think you asked for, but I think it fundamentally goes down to, as long as you are not using your apartment for the illegal activity, the legality of what you do in the rest of your life is of no business to the landlord.
Thanks so much.
Yeah, thank you. Yeah, and Wendy's making a good point that folks who are not here legally, in terms of their immigration status, if they're not documented, that could be a grounds for, you know, assuming that, well, that means their income is probably not legal. That would be an easy way for landlords to target undocumented people, and the law doesn't really give them that flexibility. Of New York City's Human Rights Commission, I believe, is pretty. They also get involved in those kinds of cases. So there's generally protections, and I think rent stabilization has not been looped into other laws so that your rights under rent stabilization are not contingent on other forms of, you know, immigration status, you know, what you do for the rest of your life. They've separated that from, it's not a contingent right. It's a right that you have based on the history of the apartment that you live in, which is phenomenal. And just as a reminder, outside of New York, there's really only one other place in the United States that has a really strong rent regulation system that I believe, which is San Francisco. There's a few places in New Jersey that have rent regulation. There's a couple of, there's a couple of spots here and there. California has a few other counties that have it, but you know, this is unheard of. This is completely counter to the capitalistic property rights ethic of this country, and is only here as a result of tenants organizing and fighting really hard for these rights. And that needs to be kept in the forefront, because A, they're going to disappear if we don't keep fighting for them. B, they could be better than they are, and people need to, you know, this is not the perfect system. This is just way better than the alternative. And C, I don't see why these shouldn't be universal. I don't see any piece of the rent regulation law that shouldn't apply to everybody. It's kind of what you would call a basic right, not an entitlement. But that's just me. Do you want to throw anything in there, Jessica?
No, Mario, I think you covered everything. Thank you. Thanks everyone for coming. Thank you, Mario, for, again, another wonderful presentation.